Thursday, Illinois in Focus Daily. I'm Greg Bishop here with America's Talking Network and thecentersquare.com. Be sure to head over there for the latest headlines from what's happening in Washington, D.C. to what's happening here in Illinois, where we focus each and every morning with Illinois in Focus Daily. All right, so a lot to get to, of course. We'll talk about a couple of different steps in some different challenges to Illinois gun laws coming up here. But we also got to get to what the FDA is doing and concerns about food additives, and even whether or not you're going to have to swipe twice to pay for services and goods, and then again for taxes and tips. So those are just some of the things we got going on. But today is Thursday, the 26th of September. While the November 5th general election is more than a month away, we've got early voting starting up 40 days in advance. You should be able to go to a polling place, like, for instance, your county clerk's office who manages local elections, and cast a ballot. You may also see a lot of various other things floating around, like mail-in ballots, and those also are available for individuals to request. Illinois law also allows you to request a permanent mail-in ballot, where every election you get a mail-in ballot to return. But some people are refraining from that and instead deciding to go to the polling place on Election Day, November 5th. But others who want to get that taken care of early, today's the day you can go to your county clerk's office and get that taken care of. Governor J.B. Pritzker yesterday asked about election issues, in particular, reacting to that measure we talked with State Representative Adam Niemerg about yesterday concerning non-citizens being able to register to vote. Here is what the governor had to say yesterday.
That's a stunt. It is already illegal to vote if you are a non-citizen. So, you can't register to vote without ID, and you can't vote if you are a non-citizen. So, that's just a stunt. That's something leading into the November election they'd like to raise. But we have no signs that there are people that are voting or have been over any of the last bunch of elections in Illinois who are non-citizens.
So the governor saying it's an election year stunt for Republicans to file that bill to make it a Class 4 felony for any non-citizen registering to vote, or any person who knowingly registers a non-citizen to vote. This doesn't have to deal with the act of voting. It's the act of registering to vote. Here's Representative Niemerg from yesterday.
In the state of Illinois, obviously, it's not going to go anywhere, but we need to keep filing bills like this. And as Republicans, we need to stand united against illegal immigration and safeguard our elections and safeguard our communities. We all know where this is heading. We have open borders. We have at least 12 million illegals that have crossed since 2021, and that's just the encounters. So it's a situation where we all see where this is going. We see the ICE facilities being closed throughout the state of Illinois. We know that the voter registration drive. And if we do not get ahead of this, they will be allowed to vote. Illegal immigrants will be allowed to vote.
So again, I just wanted to share that with you on this early start to voting in Illinois. So again, early voting starts today, Thursday. And we'll obviously take a look at the mail-in ballot numbers, because we can access, at least as far as how many mail-in ballots have been requested, and so on. So we'll cover all of that as well in the weeks ahead. All right, it is Illinois in Focus Daily. Just wanted to open with that briefly here. We will be back to talk with Todd Vandermeide about his case challenging the Cook County sales tax on firearms and a variety of other things. So stay tuned. It's right here with Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell.
1, 2, 3, 4.
Mic check's good. Stand by. Like a ricocheting bullets bouncing all over the place, a challenge to Cook County's tax on guns and ammunition. It's been around for a while now, and it seems to keep bouncing as well. To join us to talk about some of the latest developments in that case is the plaintiff, Todd Vandermeide. He joins us here with Illinois in Focus Daily. Be sure to like, subscribe, hit that notification bell for America's Talking Network, and join us each and every weekday morning live at around 8 a.m. For these types of live conversations. Todd, thanks for taking time. Just to show this really quick here, I'm going to pull up the actual docket entry from the Illinois Supreme Court. This is the appeal docket, and this is where they, very similar to how the U.S. Supreme Court does. They consider, petitions and various things to possibly take. But if you look here, filed yesterday in the docket entry 130536, Donald Todd Vandermeide et al., etc., respondents v. Cook County, Illinois, etc., et al., petitioners. Leave to appeal. Appellate Court, First District, petition for leave to appeal denied. Todd, what exactly does that mean for your case?
So the trial judge said Bruin didn't apply. And we went up to the Court of Appeals, and there was a lot of legal wrangling about what the Supreme Court's decision and the rewrite of the Cook County law and all that stuff meant, and how it was to be interpreted. And the appellate court ruled in our favor, said, no, you have to consider all this stuff. And Cook County didn't like that. So Cook County sat there and filed an appeal of the appellate court ruling up to the state Supreme Court, and the state Supreme Court has denied their appeal. So now we're back to the trial court, and we get to argue the Bruin standard, and Cook County has to defend their tax based on that.
So again, just to give some background on this, Todd, I mean, this thing was put into place when? 2012, was it? When Cook County actually passed the initial tax?
Yeah, I think so.
And then lawsuit filed. It goes all the way up to the Illinois Supreme Court, and they essentially rule against Cook County for whatever procedural issues or whatever actually policy issues.
The original case, they sat there, they ruled against Cook County, saying the tax as constructed was unconstitutional, but gave them a wiggle room on whether or not it was earmarked for certain things that might be okay. And if you'll notice in the order yesterday, it says the order will publish on 10/30, October 30th. Well, that's like a month from now. And the same thing happened in the original Supreme Court case, and Cook County took those 30 days to rewrite and amend their ordinance to think they could comply. And so now what we have is that we're saying we don't care how you comply according to what the court said. The tax is unconstitutional, and we have a challenge based on that. So now we went down to the trial judge, and right after Bruin came out, and then we said, hey, Bruin applies. This is a 2A case because the conduct is the acquisition of ammunition for firearms. This is, you've got federal court cases that say acquisition is part of the Second Amendment. So you've got keep and bear. How do you keep or possess firearms without acquiring them? How do you use firearms in training under the Ezell lawsuit, which is still good law in the federal courts in the Seventh Circuit? And because you can maintain training and proficiency is what they said. And how do you do that without a range? Well, how do you do it without ammunition? So with that, we're back in front of the judge. They're going to have to consider the Bruin standard on, I think, in the 30 seconds I just summed up, that's protected conduct. And once it's protected conduct, it's up to the state to show an analogy against, that, hey, laws like this existed either in 1791 or maybe around 1868. We know they're going to point to a couple of outmoded Jim Crow laws. They can't help themselves. They'll point to a couple. There's a tax in Georgia at one point in time, and I think the response is fairly simple. The Supreme Court said that laws that weren't enforced don't count. They also, when they've looked at Bruin and a couple other cases, the state in those cases had cited 3 or 4 territorial laws, and they said no, that's not enough. So if you don't have, in my mind, a clear majority of laws coming across, the states at the time of the ratification, you've got a hard road to hoe.
Obviously, we'll be watching that closely as in Cook County they are trying to impose this tax on ammo and firearm sales above and beyond the sales tax, so an excise tax on those things. And clearly, this is an issue the Second Amendment community has been watching for 12 years now. Pretty incredible. Todd, I want to get your take on something else that happened yesterday, because we're kind of doing a variety of different things happening in the gun litigation space, because it was a busy day yesterday, even though there weren't like some major opinions, so to speak. But yesterday, in a totally separate case, this is the Schoenthal case, the concealed carry case that was decided late last month in a district level court, saying that prohibiting individuals who have a concealed carry license from carrying on public transit is a violation of the Second Amendment. The state said that they are looking to appeal. They filed a notice to appeal. But what's interesting is back in the district court, before it even is being taken up by the Seventh Circuit, we've got this order here from the judge in this case, Ian Johnston. And I do want to just read just briefly here from the entry. Says defendant's motion contains the following sentence, and this was a motion that the defense had filed, and they say that moreover, the potentially safety implications of the court's order are highlighted by a recent mass shooting on the CTA's Blue Line, in which 4 people were murdered with firearms 3 days after the court's order was entered. And again, I think that seems to try to characterize the order as leading to that, but obviously the judge not seemingly happy. What's your interpretation of what he had to say here? The 2 signatories of the motion must telephonically attend a hearing. Additionally, if the person who wrote the sentence is not one of the signatories in the motion, then that person must also telephonically attend the hearing. Counsel should be prepared to explain what reasonable injury was done as to the legal connections and evidentiary support for the factual contentions contained in this sentence. For example, and by no way of limitations, counsel should be prepared to articulate the reasonable inquiry that was made to determine if the suspect in the CTA's Blue Line shooting possessed a concealed carry permit, and if so, whether he brought the gun onto CTA to protect himself. Moreover, counsel should explain the reasonable injury as to how the subject was protecting himself from the sleeping homeless people when he allegedly shot them. If after that hearing, explanations are as to the reasonable injury, counsel should be prepared to show cause why the factual and legal assertions in the sentence do not violate Rule 11B. Todd, your take.
The state has been smart and swarmy in their hyperbole. You saw it firsthand in their invoking of the Highland Park shooting down in Judge McGlynn's courtroom. The state thinks they can get away with this kind of hyperbole nonstop. And I think you finally found a judge who's had enough of it. I don't think Governor Pritzker's comments have helped. I just don't think this judge is going to be a punching bag for what the rule of law is. The law says X. The Supreme Court has said Y. And the state's caught in the middle for their refusal to accept what those rulings are. And the state continuously, especially, in Cook County with Kim Fox, some of the stuff she's written in briefs is just beyond belief. And I think this judge has had enough of it. It's like, you're not going to use me for a punching bag and make these kind of grandiose statements. And, normally federal judges don't have a lot of recourse in some ways. They don't take to the microphone. They don't generally issue press releases, but they do have the ability to make them answer if there's a violation of the canons or the code of conduct or the ethics. And I think that's what this judge is going to do. If you're, they've made such an astounding claim that if you're going to do this, then you better back it up. And I think this doesn't bode well for the state at all. Now, maybe they'll get off with an admonishment. I don't know. We've seen other judges remember, if I recall correctly, this was Kim Foxx and everybody trying to drag Rahimi in front of this judge and kept pestering him with motions for judicial notice, and he said, I'm aware of it, I got it, I don't need it anymore, you're wasting the time as we're trying to get this done. So yeah, I mean, just like when you were down in the courtroom down south and listening to those arguments and stuff, it's almost like the state's got a C team on the for they're not even JV for their team. And I think this is just more of that. They think they can. They think it's a political campaign that they're trying to win the hearts and minds of people. Obviously, Jabba the Hutt's that way, and yet he hasn't answered. He calls this judge in Rockford, some Trump one, and wants to harp about public safety. Well, it's not an interest balancing test anymore, Governor. In case you haven't got the letter on that, and we just had the Ninth Circuit Court of Appeals uphold an injunction to stop enforcement of a similar law on California's mass transit. Now, a 3-judge panel of the Ninth Circuit Court of Appeals upholds an injunction to bar the enforcement of a ban on carry on mass transit in California. What does that say about where we think this law is headed?
Todd Vandermeiden, always appreciate your knowledge. Obviously, we'll be watching the case where you're a plaintiff in, challenging Cook County's gun and ammo tax, but also always interesting to hear your thoughts on even cases you're not associated directly with, like the Schoenthal case about concealed carry bans on mass transit. We'll definitely connect in the near future. All right, Todd?
No problem, dude.
All right, appreciate it. And one other thing I did want to touch on here is not in federal court. It's instead in state court, and a case that Guns Save Life have filed against the Illinois FOID card. And Guns Save Life tipped me off to this. I wanted to kind of overview some of what this is here. And it's a 10-page order of sorts, but it's in the case Guns Save Life versus Brendan Kelly. And let's read through it here. Plaintiff appellant opposes defendant appellee's belated motion to stay the appeal. This appeal is fully briefed and ready for argument. Plaintiff filed its brief over 10 months ago. Defendant appellee obtained 3 separate 35-day extensions. Again, defendant appellee, the state, obtained 3 separate 35-day extensions before filing their reply nearly 6 months ago. The court set the appeal for argument, but then ordered supplemental briefings in light of the Rahimi case decision. Again, this is in state court for the appellate court in state court, Illinois. Goes on to say the parties have completed their supplemental briefings. Nevertheless, defendant now asks this court to stay the appeal pending the Illinois Supreme Court's decision in People v. Thomas. What's interesting here is the court goes on to say this particular case, which deals with somebody who had, and I did just a cursory search for this, it deals with somebody who had a firearm and a FOID card inside their vehicle, but it was apparently not broken down as it's supposed to be, transported by law, and they were charged with unlawful use because they didn't have a concealed carry permit. Regardless, that case is in front of the Illinois Supreme Court, but the state's now saying that they want to hold this particular case that Guns Save Life have against the FOID card because of this pending case, and they want to see what the outcome is from the Illinois Supreme Court. The judge in this case, and the appellate judge, talks about the difference between that case and what's being challenged here. Says the Illinois Supreme Court therefore has no reason in Thompson to apply Bruin to the FOID Card Act and determine whether the FOID Act requiring a license simply to possess firearms is consistent with the nation's historical tradition of firearm regulation. But a little bit later on, after some background on this particular case and the challenge of the FOID card altogether, I did find this interesting. It says, even when rejecting the Second Amendment argument in Thompson, the First District of the Illinois Court of Appeals agreed that Bruin identifies Illinois as falling in line with the majority of states as a shall issue jurisdiction, where authorities must issue concealed carry licenses whenever applicants satisfy certain threshold requirements. Illinois stands alone with Massachusetts, however, in requiring a license to possess any sort of firearm, not even to carry it in public. Again, recognizing the clear differences between, for instance, just merely being able to own a firearm or ammunition versus being able to carry it outside the home. Illinois was the last state in the union to implement concealed carry, something that happened, 2011, 2012, and that was after a slew of lawsuits going all the way to the U.S. Supreme Court, talking about, how prohibitions of people being able to bear arms is unconstitutional. Illinois had to put together a concealed carry system, and instead of having it as a shall issue, they had it as a may issue. Did I get that right? Shall versus may, very important distinctions here. Shall is a must issue, and then may is they could possibly issue, depending on whatever criteria they want. So Illinois is a shall issue state. They have to issue it. And then you can go through a legal process if it's denied. So anyways, regardless, this particular case that Gun Save Life have brought against the states over the FOID card, the state's continuing to try to delay getting this in front of the appellate court. And again, here's the appellate court judge saying that the standard for a facial constitutional challenge played little role in the Thompson case that the state says they need certainty on before they actually take this case to the appeals court. Similarly, the state's brief in the case cited the standard for a facial challenge in a single paragraph and its standing section. Defendant still has not identified a specific set of circumstances when the FOID Act would be constitutional. That's pretty interesting there. Thompson is thus highly unlikely to change the standard for a facial challenge or to explain its application in any way relevant to this appeal. This court did not stay this appeal pending the U.S. Supreme Court's decision in Rahimi. The long pending appeal in Thompson does not merit special treatment that would significantly delay resolution to this appeal. If defendant truly thought otherwise, then he should have moved for a stay 10 months ago. Instead, Thompson went completely unmentioned in the dozens of pages of briefings in this appeal. Accordingly, the court should deny defendant appellate's motion to stay an appeal pending the disposition of Thompson. So